Well, that was wonderful, and welcome everybody to Spin Legal. And this is episode 105 with Angela and myself. And today we're talking about the impact of Bill 60 on the Residential Tenancies Act. And note, Bill 60, which is called Fighting Delays, Building Faster Act, has an impact upon a number of other areas, including municipal bill and municipal act and building code act and a number of other areas. And we'll talk about some of those at a different time.
Yep. So there's a part 1 and a part 2 and a part 3 to Bill 60.
Yeah.
And Peter and I will talk about today the Residential Tenancies Act, about how Bill 60 impacts on the rights of landlords and tenants in residential settings,
which is Schedule 12 of Bill 60, the Fighting Delays Building Faster Act. Yep. Now, Doug Ford has been talking about this for quite some time because he's been concerned that we don't build fast enough, that there are people out there that are promising to build new homes, etc., and they don't get built.
Well, there has to be a profit to building, and the problem is nobody could afford it, what they built. And they know this.
Yeah.
So we have to start building more affordable housing. And unlike what Doug Ford probably believes in, they need some government involvement.
Okay, and just for the record, okay, so welcome, and if you need to contact Invictus Legal, you can do so at 905-688-5598, or email Angela with angela@weareinvictus.legal, or myself using peter@weareinvictus.legal, and the website is weareinvictus.legal. All right, so what we're talking about today is the impact of Bill 60, which is called Fighting Delays Building Faster Act, on the Residential Tenancies Act.
Yep. And this talks about the rights of tenants and the rights of landlords as spelled out in this legislation. Some of it is effective now, some of it is not. They're still delaying because some things they are studying for regulations, like, for example, what is persistent lateness in rent? So they're probably going to have to put something into the regulations about what it means to be persistently late in rent.
And that's probably a good thing because there's been a lot of argument over those terms.
Yeah, like what is persistent?
Yeah.
Is it once or twice? Or do you have to be late 15 times before it be considered persistent?
Yeah, well, let's say that but again, what's persistent in terms of, so you moved in, you're a new tenant of mine, and you paid me everything on the 1st of January. In fact, you paid me on the 27th of December when you moved in for the moving in on the 1st of January, and then you didn't pay me on the 1st of February, but you paid me on the 2nd of February. Now,
because I've had one person a long time ago where this person paid rent whenever they felt like it, and
that's not
in fact advanced. They actually had a credit on their account for rent. But they were deemed persistently late.
You see, when you've paid late on the second month that you've been living there, that's not persistently late. If you paid late, let's say you paid on the 2nd of March, that would also, could that be perceived persistently late? Well, it's persistent in the short term that you've been there.
Mm-hmm.
But it might not be persistent in terms of the overall time. Now, if you pay on the 1st of April, the 1st of May, the 1st of June, and then in July, you pay on the 2nd of July and the 2nd of August and the 2nd of September, are you persistently late at that point?
It could be, it may not be, depending on what comes into the definition, because they may say that if you're within a few days, but sometimes they say a day late and $1 short, and then sometimes that is the operational term.
And in some respects, the day late and $1 short scenario is actually well understood by most people.
Yeah,
say that You say that to a tenant, day late and $1 short, they know exactly what you're talking about. You say that to a landlord, they know exactly what you're talking about. Right?
Yeah. So
Okay.
what we have here is what this Bill 60 actually is going to do, and
Well,
also what it's not going to do.
yeah. Let's put the first one up there, which is 7 days to pay your rent instead of 14 if you were given an N4 notice.
So currently now, if you get an N4 in the mail about arrears of rent, you have 14 days to catch up. And if you don't catch up within those 14th day, on day 15, the landlord can take an application to the board to have you evicted.
Yeah.
Okay, so now the number will be 7 days only. Okay, it doesn't mean that, like, what people are confusing is they think that somehow this is going to make evictions quicker. It may not. Okay.
Well, I was just thinking that myself.
Stood up.
See, just because so on the 8th of February, you could actually make your application to the board, which might mean that in fact actually you get to have a hearing on the 8th of May, let's say.
Yep.
Instead of the 21st of May. Is that going to make all that much difference?
Yeah, so this is a thing that it is going to give tenants less time to catch up, okay? But who says a tenant who's way far behind is going to catch up, especially if they're further in arrears, than a month or so?
Well, again, and if you're going with an L1 application to the board, where they didn't pay after the 7 days. In fact, they never caught up they never caught up the February rent payment, and they are also then non-paying in March and non-paying in April. When you go into the hearing in May, it's assuming it's going to be in May, which is at the.
And you still do the same thing with the L1, L9 update.
Yes.
You submit that to the board.
Yeah.
And then whatever amount there, then the board will determine if an eviction is warranted upon arrears of rent, especially given.
The tenant might well fight it on Section 83 issues, which we will discuss at a later point.
That's another thing too.
Right.
Yeah.
So doesn't change the process. I don't think it necessarily speeds up the eviction, other than making it 7 days instead of 14. Unless you're going to do something to bring forward the L1 hearings, I don't know that you can speed the eviction up.
Like in some cases you can, like especially if the amount of arrears are very high and there's been some issues with even getting into the building or whatever. Sometimes you could speed up an L1 hearing, but it's very difficult. Like you could self-set a hearing date where you can go on for some of those. You could self-set and set a date. And my experience has been about 3 months from the time that you do that.
But you see, a lot of landlords I've talked to over the years have said to me they would like to see something whereby we get to a situation whereby if you're not paid up by the 7th, you could be out by the 25th, and we can therefore have new tenants in there by the 1st of next month.
Yeah, I know they would like that, but you also got to look at from the tenant's point of view.
I know.
Right? Because there's two sides to this issue. Right?
I get it. Yeah, absolutely.
Yeah, because the tenant may very well have a reason why they didn't pay the rent.
Yeah, and I think that's where it becomes problematic, because when you're talking about the reasons and not excuses, but there's always two sides to the story, as you said, right?
Yeah. Like maybe there's a serious maintenance issue and they're withholding their rent. Okay,
well,
until they can get it fixed.
Yeah, and tenants wishing to introduce matters at a rent arrears hearing must pay at least 50% of the arrears identified in the landlord's application, potentially reducing last-minute adjournments. That's the aim of this. I don't know whether that will end up in that result.
No, me neither. Me
I
neither.
think there's going to be some confusion over 50% of the arrears. Let's say that
what exactly?
Yeah, exactly. So I believe my rent to be $976.37, and you believe my rent to be $1,172.16.
Yeah, at least it was the last time I raised it.
What if I pay the 50% of what? What do I pay the 50% of? My figure or your figure?
Yeah,
Right?
exactly. And there has to be some clarity about how much that is. And also, too, what if the tenant can't afford it for whatever reason?
Well, and also, what happens if, let's say, so the 7 days before, is actually before the hearing is now the 29th or 30th of the month. So I put in my reasons 7 days beforehand, as expected. I pay my 50% because I put it in trust. Because I'm genuinely arguing these issues and I got the money, right?
Yeah.
But I haven't paid it. I paid it as it was on the 29th.
Yeah, not on the first.
In the meantime, the month flipped over and I'm now not below the 50%. Who adjudicates that stuff?
Mm-hmm.
You can see where there's going to be some big arguments about this, right?
Yeah.
And the board is probably going to err on the side of caution as a prediction, right?
Yeah, or somebody's going to go in there and said, I'm bankrupt.
And the other question about this is that I've paid 100% of my rent arrears to my paralegal.
Mm-hmm.
Right? Or I paid 100% of my rent arrears to the board.
Yeah. It's in the board in trust, or my paralegal has it in trust.
Yeah. Can you still raise those issues?
Well, if you have a paralegal, the paralegal would say, okay, they'd have to get your permission to put forward the money to pay half of the rent that's in arrears. Okay? Because you can't just dip into the trust account and do this.
Okay.
Okay. So that'll be part of your professional responsibility. And then let's say, okay, you say, okay, then the paralegal has to put that forward.
But okay, then there is another question. Could the paralegal put forward that there is $7,197.67 in my trust account that is for the rent arrears and not actually pay the money to the landlord?
Yep, that's another way of looking at it too. Okay, and saying that if necessary, I have the money to pay. Okay, and this is an L1 arrears hearing, I have the money to pay because the tenant's been paying me all along.
Yeah, because you've still got Section 83 issues.
Yeah, and this is another way that maybe a paralegal can make a sworn statement and send that off, okay? Because they would have something in trust on that one.
Yeah, but it's going to be a while before we know how this is going to effectively play out in the tribunal.
Oh, yeah, exactly. We'll have some problems because there will be some people, like, even if it's, say, if the rent is not really high, but say $3,000, but your tenant can't afford to pay the $1,500 for whatever reason, there could be some issues. This does not stop the tenant from filing their own T2 and T6 application.
Yeah.
Right? They could still do it.
Yeah.
It's just that they can't do it as a consideration with the L1 hearing.
The next one I have a particular issue with is narrowed LTB review times. The deadline for the review of a decision is reduced from 30 days to 15. I have a particular problem with something like 15 days.
Me too.
Anybody can go off on vacation. So day one, I go off on vacation. I'm leaving at 6 o'clock in the morning on day one. And at 11 a.m., the order drops, right? I come back 14 days later on vacation, and quite frankly, I sleep through day 15, and then at about 7 p.m. I start looking for my emails, and it takes me until the following day to get through, to realize there's an order against me, and now my 15 days are up.
Absolutely. And this is something where there needs to be some flexibility, like the 30 days was good enough. I don't know why they want to reduce that to 15 days. We also have many tenants who have many different kinds of disabilities. Okay, how quick somebody reacts sometimes depends on how less disabled you are.
Yeah. Oh, yeah.
Some have mental health issues.
Yeah.
Some of them have brain injury, different things like that. They may not even realize they need to review this thing or how to review this thing until more past the 15 days.
Yeah.
We've had
another issue
on the door, for God's sake, coming in.
Yeah. And another issue we have with this sort of thing is that we've got a situation whereby somebody's asked us to, they're trying to garnish their wages because of an apartment they used to live in, 7 or 8 years ago. And they left 5 years ago. Now they're being garnished for the rent arrears on that apartment, for their ex-boyfriend's rent arrears or something. How ridiculous is that?
Yeah, and this happens.
Yeah,
this happens, and somehow the person went, I want to get off the lease. I want to get off the lease. They tell them 15 times, and they write to them 15 times, and then they still somehow appear on the lease, because when someone leaves, and maybe they left the place in a mess, maybe they did some damages, maybe the boyfriend was in arrears, but then they come to me and they say, oh, now they're trying to garnish my wages.
Yeah.
But they have a guarantor and everything on file. The guarantor makes good money, everything. So I mean, this is where I ask a lot of questions. Like, this is like, you have to be very circumspect, where you have to be able to do these reviews. There has to be some flexibility when these sort of things happen. Because once
one of those
claims court, you can't just go to the small claims court and beat them up and say, hey, you got to get the order off my client because small claims court doesn't have that information. You have to go back to the board.
And part of the question that also arises in my concern with some of this is that what happens is you've got a legal representative or a landlord who can't be bothered to chase down the real offender, who goes for the low-hanging fruit. And I know that Charlie John's mother lives at 12 Maple Avenue. I'm going to serve him at 12 Maple Avenue.
Yep.
Right.
Exactly. Or I know he works at GM.
Yeah.
So I'm going to serve him at GM.
Yeah.
I hope you can just go all 1,500 employees at GM and see which one is him.
Well, the other thing about that is he works at GM, and who the hell is ever going to give up a decent job at GM, right? So,
yeah.
So I know I've got him banged to rights, and I'm just going to garnish GM for his wages because they'll just give it to me, right?
Yeah, and this is where there's a lot of things, because they have to give it within 10 days. And unless you ask for a garnishment hearing, and then that would have to be contested in a court hearing.
Yeah. But again, some of these delays, I don't know that they serve the best interests of natural justice.
Mm-hmm. Yeah, exactly. And then putting them down to 15 days, like, hey, this happened, like things happen after even the 30 days. So this is one of the reasons why you might need an extension of time. Hey, because then by the time the person discovers they're being garnished, or they're being called to court to do an examination, or had their vehicle seized, things like that, they didn't know anything about this order or where it came from until they showed up at a small claims court, and then they have a copy of the order from the landlord tenant board, which is something's weird. Yeah.
Okay, so and I think that there's an element there of the people who are doing the chasing for the money are not doing their due diligence fully.
Yeah, exactly. Like, first of all, how did the order go? Who were the people that were the main tenants? Do they have a guarantor?
Yeah.
You know, many times that the tenants, you can go after them and be getting like blood out of a stone. But if they have a guarantor, once you have it enforced against the tenants, then you can go after the guarantor in small claims through a separate claim.
Yeah.
Okay? And then you can just sue that person for whatever you owe plus costs for the tenants.
Okay. The other question that I have is, okay, so hang on, where were we? Okay. The deadline for review we were talking about. There's potential there. Okay. I actually think I've had a number of people who, over time, I just to say that most of the reviews that I've done for people who weren't customers at the time, clients who were, weren't clients at the time the order came down. Most of the clients we've taken on who had a review have been after the 15 days.
Yeah, exactly. And many of them didn't even know that they could review.
Yeah.
Okay.
Coming to it with
people don't read all the law books like we do.
Yeah.
Like you don't have them going there and looking at it. And even if they did, they may not be able to understand all the context of it.
Yeah, exactly. And the whole point is that they come along and they said the book says I should be able to do X and Y and Z, but it doesn't tell me how.
Yeah. Right? Or I went to Facebook University and said I could do this. And I want to know, could I?
Yeah. And at that point, they suddenly become appraised of their rights. And you're telling them, I'm sorry, but I don't. You have to have exceptional circumstances to have your decision reviewed after 15 days.
Yeah, exactly. And this is something where you have to pay attention. Many tenants have disabilities. Many, well, some landlords do too. But more often than not, it's in the tenants. But I've had landlords with disabilities. I've worked with a landlord who had PTSD and had trouble remembering things. And so, I mean, it depends, like people, like it applies to landlords and tenants both, this 15-day thing.
Yeah.
But I think people need to have a little bit more than that so they could at least consult somebody, after they get the order. It may take them almost a full 15 days to get some time to come in to see somebody.
Well, okay, so part of me says that I like the idea of reduced times to, for certainty, because we need to know there's a certainty. But I also like to know that there's almost the button that a person can say where they point out to the landlord and tenant board, I am going to get this reviewed, but I don't know how right now.
Yeah, but I don't know how to review it, and I have to talk to a paralegal. So they call around town. Everybody's busy until next week. Until the end of next week. So, and then by the time we get it, it may be past the 15 days.
Well, I almost feel that, let's say it's you've reached a point where you decide I feel that I've got a bad decision here. So you can kind of push that button that says, from this point, I'm going to find a professional who's going to help me, and that will give you a 10-day extension at that point.
There could be something like that, to help.
That's more or less what I would say. There needs to be this kind of log into the portal and say, I need help, right? Signal to the board that things are so bad, you've got to get help.
Yeah, and I can't see a paralegal till the end of next week for various reasons. Maybe that person's in trial. Maybe the person's very busy. Who knows?
Well, and sometimes they may have not an entry on their calendar.
Yeah, exactly. Yeah. There is a lot of reasons why people sometimes can't see it. And then, like, we try to see people, like, maybe after hours if they have an emergency. Yeah. But it's sometimes even difficult for us because we often have a couple of our evenings a week, at least, sometimes 2 or 3 evenings a week occupied. So we have to be very careful in terms of taking more time with people. And I think that that has to be taken with serious consideration about the review, the 15 days.
Yeah. Okay, let's talk about the N12 compensation changes.
That I find weird. Okay, so I suppose they're still going to ask for the 60 days and then give you back a month's rent. But if you want to do the 120 days, then you don't give back the month's rent. So what happens there is that person will be thrown out after 120 days. No compensation.
So you don't even get the last month's rent free.
Yeah, like usually you use your last month's rent while you're living there the last month. So how does that person get a first and last month's rent to go to a new place?
Yeah.
Okay, because we're talking about some people who are living on the margins.
Well, you see, one of the questions about this was always that you had your first and last.
Mm-hmm.
Right? Your last month's rent, essentially when you're getting your notice period, that the basically the 1 month compensation that you get is actually your last month's rent anyway.
Yep. And then you can go to another place and pay it.
Yeah.
Okay, so whatever it is that they have, but what they're trying to do is stop the 1 month's compensation. Okay, like, was this an issue? Like, but they're trying to give them 120 days instead. Maybe they're giving a little bit more time, but was this an issue with giving people the last month's rent?
Yeah, some small landlords I can perceive it to be an issue, but not the bigger landlords.
Yeah, the big landlords got tons of money, and they have them backed up, and they can pay it off, and they carry like sort of like
But again, okay. So I'm misleading. N12 compensation is not for big landlords anyway. It's only for small landlords anyway, right?
N12 compensation is for anybody. Well, oh yeah, that's right. For unless they're corporate landlord, they can't.
Yeah, corporate landlord.
Like corporate landlord, you can't use the N12.
Yeah.
But the thing is, paying people the N12 compensation. I mean, like that should be some kind of help, and it's a procedural thing. So I don't know whether this has actually been an issue. I've never heard anybody complain about that. The only thing I've ever heard about is the fact that sometimes tenants are very difficult to get out, even when they have been given proper notice.
Okay, but again, I don't know if you've ever seen any statistics, because I don't remember seeing any, that whereby how many tenants leave upon notice of an N12, whether it's 60 days or 4 months notice. How many tenants leave on the date on the notice? As a percentage, do you know?
Half and half. I mean,
yeah.
Like I've seen them where they continue to live. The ones that continue to stay are the ones that are going to be playing Mr. Difficult.
Yeah. Well, they're the ones who are going to be fighting it through the board.
Yeah, and they'll fight it. Well, I'm not going to go out until the board tells me I have to leave.
Yeah.
These are the
often with good reason. And for example, we've had a couple here whereby one of them wanted to negotiate. In fact, both of them wanted to negotiate better deals in terms of leaving dates. Yeah. The leaving date in question was that, hey, I need to get my kids through school, and it needs to be, for example, if we were right now, I can leave. Oh, yeah. I can leave, but if we leave before July 15th of 2026, it's going to be disadvantageous for my son. He's going to have to move school. He's in the middle of his final exams. He's going to lose chances to go to university. You know what I'm saying? Yeah. That type of thing. Whereas you've got another one that said, I'm good. I need to stay till October because of my job situation. I'm expecting to change jobs in October.
Yeah, and we've done that. We've negotiated sometimes with the landlord that have done that. And some landlords have been okay with that. Others haven't.
Yeah.
depending on their need and what they need. Because if they're having their son move in or something like that, and the son also has to start university on the date that they've given you notice for, like it's interfering with their plans, right?
Yeah.
So you have to talk about it, and it works both ways.
Yeah, absolutely. And notice that this is talking about an N12, not an N13.
Yeah. And N13 is different. And N13 is about demolition or renovations or difference of use.
Yeah. And that's entirely unaffected by these changes.
Yeah.
Right.
So
Okay.
given
So
120 days, it actually would give them the equivalent period of time as an N13.
yeah.
Okay. So that would give the tenant technically 4 months to get out.
Yeah. Okay. The other one is Section 5811 of the Act provides that persistent failure to pay rent on the date it becomes due and payable is to be determined in accordance with the regulations. We kind of talked about this one, didn't we?
This is not yet put into the writing, because they'd have to define what is persistently late. So they have to define that. So that's when it says this will be put into the regulations. So this is when regulations have to be written to match the legislation, and it hasn't done it yet.
Oh, the thing is about that is that probably what is going on at the moment is a consultation exercise in the ministry where they actually have been talking to a number of people, including, let's say, for example, LTB adjudicators that might well be on that list about what would you consider to be persistently late? Could you help us give a definition?
Yeah, and I wish they would talk to the legal profession too.
True.
We're the ones who go before the board and we defend people or prosecute before the board. So the thing is, we have to be able to have a say in how that this is going to work. I have some concerns because we have some people going all over the place who are representing landlords and say, oh, good, faster hearings, faster evictions. And I look at it, sorry. Doesn't mean you're going to get a faster eviction.
The only way I think you can, and I know you'll argue against this, the only way in which you can get a faster eviction is if you've got kind of paper decisions being made.
Yeah, they did that under the Tenant Protection Act, and then most of them were challenged, and it caused a lot of reviews.
Oh, I get that. And as I said, I knew you would object.
Yeah. Well, it just that I have experience when it was a Tenant Protection Act, and they did allow that. And tenants say, I wasn't served.
Yeah. Yeah. Okay. And a notice under the Act shall be given in the form approved by the board unless a form is prescribed, in which case the prescribed form shall be used. In other words, I can see them creating new forms here.
Yeah, and people have to use those forms.
Yeah.
I don't know what they were doing before. Like, I've always used the forms, but have some people not used the forms and just wrote them a letter saying all the stuff that it says on the form, except what the tenant's rights are. Because the forms have to explain what the tenant's options are at the end of it.
Well, there is a couple of forms that I've noticed that they seemingly have taken away, like a notice to withdraw.
Yeah, notice to withdraw. Don't they have? They would have that.
There was a notice to withdraw at one time, and now there is not.
Recently, I did a withdrawal for 2 cases.
Yeah.
And I sent it in. And then they sent me back an acknowledgement, and then they withdrew it.
Yeah. Oh, that's fine. I've never had a problem about writing my own notice to withdraw.
Notices to withdraw, which is kind of weird. I don't know what's going to happen. Or do people have to appear and say they withdraw? Which is going to be a pain in the neck.
Yeah, there is that as well.
Yeah.
In fact, actually, the one I did was withdrawn at only about 5 days' notice. So, it was done in person.
Mm-hmm. Yeah.
Right? Because in that scenario, even if you put a form in and the form is properly recognized by the board and is signed by the other side, which is quite a mouthful actually to even get done, because even when the other side has agreed on the withdrawal. You
Or
know,
an adjournment, another thing.
or an adjournment, yeah.
You both agree with an adjournment and you put your best dates and all that stuff in there. Hey, one of us got to go to the board and speak to it.
Yep. Oh yeah, exactly.
Yeah,
And that's all too often the case where we end up speaking to the matter anyway. You know.
exactly.
Yeah. Okay. All right. There was a couple of other things. Okay. One of the most horrific ideas here is a bad tenant database.
Yeah, although it's not put into proposed legislation on Bill 60, there has been a lot of lobbying going on about getting a bad tenant list or a bad tenant database. Whereas somebody can go on the internet and search up someone's name and then find out if they've ever been evicted or if they've ever been found to be in arrears, that sort of thing.
Well,
That's pretty risky in terms of privacy laws and also.
Well, I have a problem with that because here's the thing. I've been a tenant with John Smith for 15 years. Never late until the last 7 or 8 months. And I stick my hand up and say, yes, I was late the last 7 or 8 months. I lost my job. My wife divorced me, and etc. 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 I've just been through hell, right? And now, now you're evicting me. Okay, that's fine. I'm going to spend some time. I'm going to spend some time couch surfing. So I spend time couch surfing. And then in a year or two's time, I get myself back on my feet. I get another job, and I'm now back in a situation whereby I've got the money to go and rent a decent place again.
Yeah, and I got a steady income again.
Yeah, but I'm now on a bad tenant list.
Yeah.
How do I get out?
Yeah. How does somebody leave a bad tenant list, and how long will it take to get out of a bad tenant list?
Yeah.
And also, what type of information is going to be provided to people?
Yeah, and those situations that I described are situations that anybody could have gone through, right? You lost your job, long-term job. Your breakup in your family. Those are situations that anybody could face.
Yeah, exactly. And the thing is, there's a lot of difficulty. Same as some people say, I want to have a bad landlord list. Okay? So they have a slumlord database that anybody could look up, and then they could find out that they've been slumlords for years, and they give a lot of N12s and bad faith and so forth. And the thing is, like, how fair is that?
Yeah.
Okay? Maybe
both
the sides of up after the last time.
Yeah, both sides of the equation have got unfairness built into it.
Yeah,
because
exactly.
And nonetheless, because hey, because Smith and Company evicted me, therefore I've got this thing about Smith and Company, and I'm going to slander their name across the whole of Ontario, New York, Montreal, and everywhere else I could possibly think of.
Yeah. And there's also a few other things here that they're looking at here about restricting use of set-asides to evict tenants without a hearing. That they want to look at what conditions must be met for the LTB to grant a set-aside motion. Right now, people can do a set-aside within, I think, 10 days or something right after they receive the order. But they could pause the eviction and then request a hearing at the LTB, for example, to dispute the alleged breach, like say if you're going on a Section 78. This is a problematic because, like, what are they going to be setting as conditions? Many times the tenants don't even get notices. Maybe they didn't appear at a hearing.
Mm-hmm.
And then they get this order in the mail and they didn't even know the landlord was trying to evict them. There are cases like that, and we found them. Okay? Because some landlords like to take a few shortcuts.
Yeah.
Okay? And then you have to come back in and have it disputed, or you get locked out, okay, for things. So there has to be ways of getting that back in, and there has to be a right right to review. A right to review should be pretty general. And these things are backed by courts. You have to realize that the tribunal is also overseen by the Superior Court of Justice. So to try to restrict it much further, you're going to be creating less rights of oversight.
Well, I also have to ask the question, what's going to be the longer term view of the appellate courts on this?
Yeah, the courts might strike a lot of it out.
Yeah.
Okay, just like they did with the TD Monex insurance case. There was certain cases where you couldn't do an actual appeal out of a judicial review. There's a whole lot of different things that people have, where people should be able to have more freedom to bring to the attention of the courts when a tribunal makes a ridiculous decision.
Yeah.
I mean, I'm not saying tribunals always make ridiculous decisions. I think
Well,
they
I know
try
you're not.
best,
Yeah.
but people make mistakes.
And let's be honest about it. Even if you're negatively affected by a decision at the board, when you sit down and look at it, and you think, once all is said and done, you kind of go, well, I can't argue against it. It's against me, but it's not arguable on law.
Yeah. Yeah, I made the noise. I created a disturbance. I had 15 people over at my house. I partied till 3 a.m. And then after I had a warning, I did it again 2 weeks later. So I mean, so be it.
Yeah.
I should have volunteered to leave and came up to an agreement and left what the landlords told me to.
Yeah.
So I mean, these are things that happen, or if you're in arrears, kind of get a payment plan. You can still do the payment plans. You can still do all of that stuff. Nothing's stopping anybody from doing that. But it's just there's a lot of restrictions that are being looked at about where there are restrictions like what would be considered a Section 82 circumstances or a Section 83 circumstances that a person can complain about. Again, that may be looked at, may be frowned upon by an appeals court if they try to put too many restrictions in there.
Have you got any further items to cover on this?
Yeah, I would. I would say that people have to move along with this bill with caution. We're not going to get quicker hearings by this unless they staff the tribunal more and have more hearings like in a single day, because when I first started practicing and I made an application, I had a hearing within 4 to 6 weeks. I don't know what happened. Maybe the board applications exploded since. I don't know. Hey, but
I think there have been.
Yeah, because for some reason we're getting a lot more hearings.
Well,
and they fell behind and they're still trying to catch up.
You recall that there was a situation after COVID when they were talking about when the problems in the LTB were so paramount that the Ontario Ombudsman looked at them and produced a major report about them.
Yeah, and they stopped the hand of the government.
Yeah, they were talking at the time about there being an arrears of 30,000 cases in the board. And in fact, actually, the numbers of cases going through the board on a monthly basis has now gone up.
Yeah, exactly.
Because
with an increase in adjudicators, you can do this. And you also have to have staff to support the adjudicators.
Yeah.
Because I was talking to one of them who was an adjudicator on the board, and he left because the adjudicators were not given staff assistance. They had to write up all their decisions, write up all of their stuff, hand it in, and he was only a part-time adjudicator.
Yeah.
And he found it stressful. Because
a part-time adjudicator doing full-time work.
Yeah, exactly. You end up full-time even though you're a part-time adjudicator. And I think what they need to do is if someone's a part-time adjudicator, they are a part-time adjudicator. If someone's a full-time adjudicator, they're a full-time adjudicator. But there should be staff somewhere where each adjudicator could send their messages, get that done, and they say, okay, this looks like this is a decision. Because one of the things they're trying to do is they're trying to get it so that adjudicators' decisions are pretty uniform. They're trying to make it more uniform across the board, which I think is a good idea. Because you know how they always say if you go into a room and ask 10 different lawyers their opinion, you get 11 different answers. Hey? It's like going to the board 10 different times and getting 11 different orders. So
Yeah.
I'd like to see if you can get, if you go to adjudicate
again,
times, that they be the same kind of order, same basis.
and again, whilst if you and I were on different sides of the case, we're putting to the adjudicator, I'm going to say cases A, B, and C apply to this rule, and I'm going to give you the case law, give the adjudicator the case law, which is going to affect their decision. And you, on the other hand, come along with cases D, E, and F about how that goes to the board. But both of us have missed the point entirely. We crossed somewhere like this.
Yeah.
Surely there has to be a point at which the adjudicator needs to turn to staff and say, I don't believe that Peter's correct in his case law, and I don't believe Angela's correct in their case law. What is the correct case law for this situation?
Mm-hmm. And this is why I think they're both incorrect.
Yeah.
And then they review specific case laws about why it's not correct. And then they say, okay, I'm substituting for this.
But sometimes they need somebody else to do that research for them.
Yeah, exactly. Have somebody in the office who's a crackerjack at this type of research and will be able to say, okay, this one would work or this one would not work. Like the Human Rights Tribunal, they have people there. They have a commission that also could submit ideas or submit cases or intervene in cases. And they also have the Human Rights Tribunal itself. And the Human Rights Tribunal, I can quote several decisions made by the Human Rights Tribunal by cases and use them as precedents. And it's harder to use landlord-tenant board cases as precedents because someone would find the same situation and was decided differently by another adjudicator.
Well, that is part of the problem. Is adjudicator Thompson made decision A on the set of facts, and adjudicator Abdul made decision B on the same set of facts, and they're opposite direction, going in opposite direction.
Decisions, yeah, and this is where, and they are trying to see what they can do to make them work together. This is one of the problems with tribunals, and it's inherent with tribunals. And you have to, this is why you need staff, you need legal counsel, you need people to support the adjudicators who are working there so that they have the type of guidance, they have the type of precedents and that sort of thing to support them when they write up their decisions.
Yep.
And from what I think is, I don't think that they have the staffing that's required to actually make this board work the way that it really should work. Because I really like to see the hearings take place within 4 to 6 weeks. That way the landlords lose less money in arrears of rent and tenants wait less long in terms of getting repairs and other types of things addressed.
Yeah. And that means all of them, that whether you're doing an L1 hearing or a T2 application or a T6 application, they should all be, the board should aim to hear them all quickly.
Yeah, exactly. And that way, because right now it takes longer to get a tenant application in than it does for a landlord application, particularly an arrears application.
Yeah.
And we have to really do this. And I think they have to be really careful about the restricting of certain rights to appeal or rights to review and keep the 30-day.
And I think that nobody, whether you're a landlord or a tenant, will disagree that non-payment of rent needs to be taken the most serious of all of them.
Absolutely.
It needs to be absolutely dealt with at highest priority.
Yeah, because who wants to take a money-losing business?
Yeah.
You know, because that's what it is. Many landlords are running money-losing businesses.
Yeah, yeah. But again, there's a lot of other decisions that have to be made that are not about non-payment of rent.
Yeah, exactly.
There's a whole wealth of other issues.
Contract decisions. There's no fault decisions. Say if I want to demolish a place or I need to, there has to be some rights there too. I represented in 2 demolitions, and tenants were very difficult in these demolitions. One of them thought he owned the place, and the other one thought that she could just manipulate my landlord with all kinds of things.
Yeah. Well, and the worst about some of these sort of demolitions, especially when the demolition is backed by like fire code or building code problems,
Yeah.
that they
be reported to the building code.
Yeah, the building may be in dire need of being demolished because it wasn't up to building code since 1954.
Yeah. Yeah, and we still got to give an N13. We still have to give the warning, and we still have to give compensation, depending on the number of units in that building.
Yeah.
So
and unless
very serious. Like we've been in situations too before where we've also handled N13s, where there was a reno or a demo, and then they had to change it back to reno. I mean, these things could be like these things have to be very much defined. And I think renovations has to be defined, demolition has to be defined, so that landlords have better guidance, so they don't go in one form and then get told that that's not what it is. It's this thing instead. You got to start all over.
And in fact, actually, I would say that there needs to be one definition that is used by all municipalities that is common across the whole of Ontario, and that there's an application for demolition and what it specifically means, and there's an application for renovation and what that specifically means.
Yeah, because we got some case laws defining demolition as creating more apartments on a floor of a building.
Yeah.
Hey, or changing the layout of a place substantially. Hey, but that's not really, and that was ruled down by one of our adjudicators when we tried to argue that that was a demolition, and we used case law for that, which supported the definition of demolition for that.
Yeah.
So if they're going to do that, let's tell everybody what demolition is, what renovations are, what conversion is.
Well, and we started with the question about persistent lateness here.
And persistent lateness.
Let's define what the terms actually mean.
Exactly. Does it mean 2 times they paid late, or does it mean 15 times before you can be considered for an eviction?
Yeah.
Okay. So there has to be some definition about what it means to be persistently late.
Yes.
And what a landlord needs to do to prove it.
Yeah, exactly.
Okay. So these things make it easier. I mean, these things like that would facilitate the workings of a board, and also be able to get the parties to have some clarity when they come before a hearing.
Yeah, and you also know that you've got to give this evidence A, B, C, D. Right?
Yeah, exactly.
And without those specific items in evidence, you're not going to win your case.
Yeah.
And in fact,
say help people when they can't figure out the technology about this or how to send in applications and so forth. Because a lot of people don't. I've had landlords who don't even have the necessary knowledge.
Yeah. Well, that's another matter entirely.
They come in the office, they show up, and we work with them on it.
Yeah. All right. Moving. Okay. So I don't think there's any other issues we need to discuss.
Nope.
No.
Nope.
So just want to say to everybody, if you need to contact Invictus Legal, you can do so on 905-688-5598. Email Angela with angela@weareinvictus.legal, or myself using peter@weareinvictus.legal. And the website is weareinvictus.legal.
Yep.
And Angela, here you go. Oop.
Okay. So what you heard today on Spin Legal, whether it's on this show or other series in the 104 other series, it's not legal advice. If you need legal advice, please go to a lawyer or a paralegal. And I hope you come to Invictus Legal, because we can help you and guide you in different directions. But as I said, but do go to a paralegal or a lawyer. They can give you specific advice on what you have. Facebook University doesn't give it to you, or Google LLB doesn't give it to you either. So I think you really need to talk to someone who is professional, nor does ChatGPT, apparently.
Well, actually, that's an interesting thing you say that. ChatGPT has recently changed. The latest edition of ChatGPT will not write legal briefs for you.
Yeah, or diagnose you.
Yeah, or diagnose you. Yeah. Thank you
so
very much.
For the next time that we come back for Spin Legal, we're going to talk about the next part of Bill 60. So there's municipal parts, and there's building parts. There's other parts of Bill 60 that affect other areas.
Yeah, exactly.
Which was recently introduced, and we'll explain it to people so we can put it in plain English with folks.
Yeah. All right. So have a great day, great week, everybody, and we'll see you.